Welcome back. You're tuned into Startup Central, and today we are talking about DPDP and what this really means for the common citizen. In fact, government has notified the final DPDP rules. The rule includes setting up an appointment of core members, including the chairman. We have Qasim Rizvi, who's the founder director, the Dialogue, and Dhruv Garg, partner, IGAP, with us to understand more about the DPDP rules. Hi, good evening to both of you. Thank you so much for joining us. Now, firstly, what does the enforcement of DPDP Act mean for the average Indian citizen with the implementation of the law? Dhruv, why don't you go first?
Sure. Thanks, Sangeeta, for inviting us. And I think I can say for myself as well as Kazim, I mean, this is a very exciting time for all of us. And this is something that is at least 15 years in the making from the first time DOPT released a paper on as to the approach of privacy, correct? It took a lot of committees, Supreme Court 9-bench judgment, to multiple sort of drafts of the act. And now the rules are released. So at the outset, what does it mean for a general digital Nagrik, as we understand, correct? This act and the rules create a set of rights for each and every citizen in this country, or anyone based out of this country, who is interacting with any kind of digital data processing or any kind of entity which is processing the digital data. What does it mean? It means that I have the right, or any of the citizens have the right to know what my data is processed for, correct? I have the right that my consent is taken for the purposes for which the data is processed. I have the right to know exactly what all it is being processed for. I have the right to erase the data when the purpose has ended. I have the right to correct the data if there is any inaccuracy in that data. I have the right for data portability, correct? I can carry my data from one place to another. And I have a right to raise a grievance if any of these rights are not met, correct? First, to the what we call data fiduciary, which is the entity which is processing my data. And if they don't, then obviously I can escalate it to a data protection board as well, correct? So I would say out and out, as more Indians are interacting with the digital world, this set of rights created for protecting their privacy and giving them an autonomy over a set of these rights is the most important thing brought on by the act and the rules, correct? And I think that's a brilliant development. We had seen EU doing it through GDPR. There are the different jurisdictions we're doing it, but now India has entered into that stage where they are giving autonomy to the users over their privacy rights.
Qasim, coming to you then, is India's DPDP Act comparable to global benchmarks like a European Union's GDPR, or is it just a fundamentally different model?
No, thank you. First of all, I think it's a momentous occasion for all of us to have the first Data Protection Act in India finally notified. To your question, India's act is tailored to the Indian requirements and Indian businesses and Indian people. I think the advantage for us has been that we've been able to learn from some of the mistakes other jurisdictions have made. And we often talk about the Brussels effect. And of course, we've seen the implementation of GDPR over the last few years. And obviously, there have been some challenges with respect to how European businesses have now started complaining, and there have been some conversations around the fact that GDPR is a little restrictive. So I think the Indian policymakers, lawmakers have been very pragmatic in the way they have come up with the DPDP Act and now the rules, which is not very prescriptive from the get-go. It allows for businesses to grow, and it allows for the fact that you're looking at the emerging technologies as well. But at the same time, I do want to highlight that, looking at the advent of AI and looking at the advent of how AI systems and models are operating, I think, we also need to understand and maybe look at some of the provisions within the rules and the act itself to be able to say that, okay, is it going to restrict the development and growth of AI in India? And I think with respect to this, one input which I had was the fact that the law doesn't have legitimate interest, and it has only notice and consent as the base for lawful processing, right? Whereas, in other jurisdictions, you might find other lawful processes, a lawful basis for processing as well. So I think maybe there is sometime in the future, the government could consider that, okay, should we need to introduce another lawful basis for processing of data? Do we need to allow for some evolving models? Because if you look at AI, I mean, the models rely on a lot of unstructured, large volumes of data. While you have the exemption for publicly available data made publicly available by the data principal herself, it's very difficult to implement that, because it's very difficult to determine that, okay, who has the made this data available publicly. So there are certain areas which may require more discussion, but I think, the good should not be the enemy of the best, or the best should not be enemy of the good. And I think this is a very important step in the right direction. And I do believe that, looking at the way the process has been, it has been a terrific consultation process over the last 8 years, since the time the Puttaswamy judgment came about and the right to privacy was guaranteed as a fundamental right to the people of India. So we hope, and we are pretty sort of convinced that in the future, as the act gets amended and new sort of amendments come through, it'll follow the whole consultation process. And I do believe that with the way technology is moving forward, we'll have to be on our toes and agile with respect to regulatory innovation going forward.
All right, Dhruv, then coming to you, what are the immediate compliance obligations that businesses must meet now that the law is in force?
uh, uh, there is enough timeline. So just to look at the timeline, there's a concept of consent managers, correct? There is a 1 year time period for that to kick in. There's an 18 months time period for most of the obligations on the data judiciaries and processors to kick in, correct? So there's a 18-month timeline for all of this, but the kind of obligations that will kick in, and as we were discussing earlier, was that they need to figure out and do a gap analysis of all their processes. They have to figure out that on what basis are they processing data. They have to be very unambiguous about the purpose, the itemized types of data that they're asking a user to provide that consent for. They have to also be prepared for receiving grievances from the users vis-a-vis their rights. They have to ensure that they have communicated to the users and have inbuilt mechanisms to correct data if it is inaccurate, to erase data if it is if the user believes so. If the user withdraws their consent, they should have systems to make sure that the data is not retained beyond the lawful time period. Additionally, there's a concept of significant data fiduciaries. Over there also, if you are notified as a significant data fiduciary, then you need to have a data protection officer. There are slightly higher burden in terms of auditing as to the impact of these mechanism as to how you're processing data, etc. So there are a bunch of obligations vis-a-vis the user, vis-a-vis the significant data fiduciary. There is also obligation for notifying for any breach. So if there's a data breach, if someone has hacked the data and there is a data leak or a data breach, then the data fiduciary has to inform both the data protection board as well as the user as to the specific of that breach, correct? They also have to maintain certain reasonable security measures in place for protecting that data, correct? There's certain sort of guidelines given. Generally, there's no standards per se prescribed right now. It's the term is reasonable, but those kind of reasonable security safeguards also need to be baked in. So there is a plethora of compliance and obligations that these entities have to undertake, and they have to do a gap analysis and implement these all in 18 months from the date the rules are notified.
Right. So, Qasim, how prepared are Indian companies, especially the MSMEs, for mandatory consent, notice, and even data protection requirements?
So if you look at the Indian businesses, and many of the businesses in India, I can at least speak for the medium to large businesses in India, are, I think, ready for compliance when it comes to, revisiting their workflows, revisiting their internal processes, all the tools which they have embedded. Because if you look at data protection, and of course, with GDPR, this conversation started to pick up. Data protection is no more a compliance requirement for businesses. It's a competitive advantage for businesses. And I think if most of the companies are looking at it as a competitive advantage to build trust with the people of India. As we are entering into the AI generation, and as more and more data is collected, processed for various purposes, this act really brings towards a very structured process to how a citizen's data will be used, how it will be monetized, and what are the rights of the citizen in the digital economy. So yes, many of the companies are ready, but of course, for MSMEs and small businesses, they will require capacity building, they will require awareness. And the government has been doing that. And the government has done multiple awareness programs, capacity building workshops and sessions with small businesses, with startups, to build this thinking that this is a watershed moment for India's digital economy, and all of us have to be prepared to make sure that this is a success. So Indian businesses are getting compliance ready. Many of them are, and as Dhruv rightly pointed out, the time period is sufficient enough. You have 18 months to sort of be ready with your compliance processes. Some of the provisions are already in place, like the data protection board. You have the definition and the scope. All of that is already in place. And of course, after 1 year, you have the consent manager registration rules, eligibility, etc. So the staggered timeline allows the businesses to start getting ready, and it also allows the management to revisit their internal workflows and to have a data protection assessment, an internal data protection assessment, to understand what kinds of data is being processed, for what purposes, because we are moving towards a notice and consent regime, and we are moving towards a purpose limitation regime. So you have to have notices given to the citizen. You have to make sure that you take the consent, and there is a process which has been developed to that effect. And I do believe that the government will continue to do more consultations and discussions with the industry to make sure that the process is smooth, because we are moving towards uh, regime where data protection will become fundamental to how India's digital economy will evolve. So I think it's imperative for each business to now start looking at data protection very, very seriously. It's a compliance requirement. And for all the new businesses which are processing personal data, I think from the get-go, start developing your internal processes in a way that by the time the timeline arrives after 18 months for the act to be in full force, you are ready, and you can sort of go ahead and really deliver the business objectives and make sure that you're compliant with India's data protection regime. We saw similar aspects when GDPR was being implemented. So it's quite natural that the timeline is provided to make sure that the businesses are prepared or getting prepared towards the eventuality of the implementation of the law.
Okay. Dhruv, let me come to you then. How is this likely to impact the startups then?
Yes, it's an interesting question from the point of view. If you look at what just Kazim said, correct? I think there will definitely be a significant cost attached to the compliances required under the act and the rules. There's going to be significant efforts, not just in terms of monetary terms, but also the time and mental bandwidth that will startup will have to spend in figuring out how to comply. But as Kazim was saying earlier, correct, that there is an innate value attached to the trust factor that this brings in, correct? There was whenever there was talks about digital economy and how if something is free, you are the product, or we don't know how your data is being used. That kind of questions will be answered equally by the big firm and a small startup, correct? It was usually believed that a bigger firm will give you more sort of trust and safety, while a startup may not. But because this is an equal playing field, everyone has to comply with it. So that trust factor will definitely go. So if the question is whether it will be difficult and it will cost both in terms of time, money, and mental bandwidth, yes, it will for startups, and they will have to figure out a way to deal with it. But on the flip side of it, there is going to be a trust gain from each and every user for all of these startups. And I think we have to value it while thinking about it.
Kasim, Dhruv, thank you so much for taking the time out and joining us on this discussion. With that, we will let you go and slip into a short break. Don't go anywhere after the break. We are coming back with more news and updates. Stay tuned.